On the record, we're rolling.
Thank you. Back to the record. Please, Mr. Takei, it's still your case.
Thank you. I would like to call Ms. Donna Campbell.
Ms. Campbell. Ms. Campbell, I just remind you that you're still under oath.
Yes.
Thank you. Mr. Takei.
Thank you. Ms. Campbell, when were you hired?
In October 2nd of 2010. Actually, that was my second hire. I was originally hired in 2000 to 2001, I believe, for 1 year period. And then I left after that, and I came back to the Department of Education in 2010, October.
Okay, did you say the first time was 2001 to 2002 school year?
No, it was, I believe it was 2000 to 2001 school year.
And based on those two periods, or those two times that you were hired, you would agree that on both occasions, you were never a new hire teacher entering the salary schedule in 2021 through 2023, correct?
A new hire in 2021? No, I was not a new hire.
Okay. And when you were a new hire teacher, you received 6 years of credit for your verified non-BU5 service, correct?
You're correct.
And this credit advanced you to a higher salary step than you would have been without the non-BU5 credit, correct?
Correct.
And at the time of both hires, of the 2000 to 2001 school year, and then the second time, 2010, you were placed with in-service teachers with equivalent years of credited service, correct?
Credited or earned service.
Okay, sorry, in service. With in-service teachers with equivalent years of service, correct?
Correct.
Okay. And do you know okay, where did do you know where did you work for the 6 years you got non-BU5 credit for?
I worked the entire time for Sacred Hearts Academy.
Okay.
Here in Honolulu.
And during that time, you were not also a Department of Education employee, correct?
That's correct.
And during that 6 years away, you were not a BU5 member, correct?
Actually, it was the 10 years that I was away, but during the 6 years that I was credited, you're correct. I was not a BPI employee.
And you didn't receive pay from DOE during that time, correct?
No, I did not.
Okay. And during that time period, you did not experience the same step movements or lack of step movements that teachers within BU5 experienced during that same time period, correct?
I wouldn't know that. I was not privy to the information within the Department of Education at that time. I only know what I experienced at Sacred Hearts Academy.
Okay. I guess, Ms. Campbell, is it possible, or would you agree that it's pretty unlikely that as a non-BU5 teacher during that time, you would have experienced the exact same experience of step movements or lack of step movements as a BU5 member?
That would be purely speculative on my part. I have no idea what somebody experienced here in the Department of Education compared to myself at a comparable situation in Honolulu. So I have really no idea.
Well, I'm just asking, don't you, would you agree it's pretty substantially unlikely that you experienced the same experience?
No, I can't say that. I worked in Honolulu. I worked at a school, and I don't know what the policies are at the Department of Education at that time.
Okay. During that time period, you did not experience the same effects resulting from DOE's recruiting difficulties that teachers within BU5 experienced during that same time period, correct?
Once again, I can't speculate on the Department of Education's policies at that period of time.
Okay. In 2022, when repricing was implemented,
Correct.
what was your step placement before repricing was implemented in 2022
Step 11.
and after repricing?
After repricing came into effect, I lost my 6 years of credited service, and therefore I remained at step 11.
So before and after repricing, you were on step 11, correct?
Correct.
And do you remember what your salary was in 2022 before repricing?
No, I don't.
Can you turn to E52? At the top, it's E52.
Okay.
Okay. And if you can go to 1, 2, 3, 4, 5, 6 lines from the bottom.
6 lines from the bottom.
Sorry, that's a little fuzzy.
It's a little fuzzy, but
Okay, the line that has July 26, 2022. If you go
Yeah.
across.
Yeah.
I believe that says $6,511.
I believe that's correct.
Okay, does that, do you have any reason to, question that?
No.
Your salary was that amount?
I have no
Okay, thank you.
reason to question that.
That it was that amount before repricing?
Correct.
And was it that same amount after repricing?
After repricing came into effect and I was no longer credited with my 6 years of service, I remained at the same salary.
So you remained at the same salary before and after repricing, correct?
Yes.
And you would agree that the CBA and the salary schedule did not change in any way as a result of repricing, correct?
Correct. The CBA and the printed CBA and the salary schedule found within the CBA did not change.
Thank you. You would agree that repricing was based on BU5 service only, correct?
That was the Department of Education who made the decision to no longer include my 6 years of verified service. So at one point, the collective bargaining agreement, which had originally included my 6 years, changed the matrix of how they were going to pay me and how they were going to value my 6 years of credit. And they no longer included that 6 years in the repricing. So
Yes. BU5 service only?
It was BUI 5 service only. I'm not sure when that happened, but that was what repricing did. It changed the metrics on how we would get credited service.
Okay. And you would agree that the location of where you were born and raised was not a consideration for repricing,
No,
correct?
it was not.
And neither was your race
No, it was not.
or skin color?
No,
Okay.
it's not.
Now, I want to move on to your claims against DOE. But in the interest of time, I was wondering, did you hear each and every one of my questions towards David Reid regarding his claims against DOE?
I did hear them.
Okay. And did you hear and understand his responses to my questions?
I did hear and understand, correct.
Okay. And generally, do you agree that the claims, oh, I'm sorry. Is your claims identical to those of that explained by Mr. Reid earlier?
I'd like to speak to 89.9 with the impact changes on wages and the use of F1 or F2.
And Ms. Campbell,
Pers-
before you continue, and Mr. Takei, I don't mean to interrupt your line of questioning, but there was quite extensive questions and answers, to Mr. Reid. And I think to be asking this witness that if she agrees or disagrees in just in a lump sum type question, I'm all for saving time, but I don't feel like that is a very fair inquiry into this. So I'm going to let you proceed, but I'm just letting you know that I do have a concern about trying to lump everything together like this, just from an interest of fairness.
If the witness is okay with it, board be okay with it.
If the board's not okay with it, we're going to be not okay with it. So I'm asking, you can proceed, but I'm just letting you know that, to attempt this line of questioning, I'll let you proceed with your questions, but just be cautious.
Okay, thank you. With what you did hear Mr. Reid testify to, do you disagree with any of the testimony that he gave that reflects? Do you disagree with any of his testimony as it relates to your individual claims against the DOE?
Perhaps we will go through each of the claims and I can say whether I agree with Mr. Reid or not. And rather than it maybe in the interest of time, but just so that we can identify each of the claims and then I can elaborate on any that I do not agree with.
Sure. Thank you. Okay. You alleged in this case that DOE committed prohibited practice under 89-13-A8 by violating the terms of the collective bargaining agreement, correct?
Correct.
Now, are the violations you alleged based on Article 20C and E, Article 24C, and Article 25A, as Mr. Reid testified?
Okay,
You want the collective bargaining?
please. I guess, basically, I'm not an attorney. I don't remember what all and each of every one of these articles represents. What I would like to say is that wages were changed. And that is an infringement upon my right. There was no collective bargaining done. The state has said that they repriced through through F2. I would like to provide some clarification to the board because I'm not 100% certain, because many teachers do not understand the schedule and they don't understand.
Objection, unresponsive.
Ask your question again, Mr. Takeo, maybe rephrase it.
Sure. My question is, are your allegations of breach of contract against DOE based on Article 20E and C, Article 24C, and Article 25A?
You understand the question? Ms.
Yes, I
Campbell?
do. Sorry, I was just looking up because
No,
he's
that's
going
fine.
through a few of them. So I just want to make sure. So I agree with Mr. Reid's responses in response to those articles and to those claims by the claimants. I do want to bring up my concerns for the understanding by the board of the teacher schedules and what repricing means.
Okay, until that point,
I do agree with the responses that were given by Mr. Reid
as it relates
as it relates
to
to,
my questions that I gave to him earlier.
Yes.
About the claim of 89-13-A8, relating to your claims of violating the terms of the CBA.
correct.
You understood each of my questions that I went through regarding that particular claim. And you heard his answers and you agree in whole as to what his responses
His
were.
responses, I do.
And you have nothing to add. As to the claim of violating the collective bargaining agreement.
Correct.
Okay. Thank you. As to your claim of violation of 89-13-A1, which, if I can direct your attention to 89-13-A1. Do you have a copy?
No.
Oh. Okay, you made a claim against DOE based on that statute, correct?
Correct.
Okay. And then that statute reads, that it's a prohibited practice to interfere, restrain, or coerce any employee in the exercise of any right guaranteed under this chapter, correct?
Correct.
Okay. My question is, what specific right guaranteed under this chapter are you alleging to have been violated?
Could you repeat that
Yeah.
question?
So it's a prohibited practice if DOE were to willfully interfere, restrain, or coerce you in the exercise of your right guaranteed under this chapter.
Thank you.
And I am asking you, what right under the guaranteed under this chapter are you alleging to have been violated?
I believe that there was evidence of bad faith on the part of the Department of Education. I contacted the Department of Education in October prior to the compression adjustment, and I was sent emails from the personnel department at the Department of Education indicating to me that compression was going to be implemented and that there was no appeal to compression.
Okay, so
So I believe there was an evidence of bad faith. There was interference by the Department of Education and coercing me into believing that there was nothing I could do about it. This was going to happen. And I was an employee of the Department of Education, and there was no appeals process to compression.
can you specify what right you are saying was violated?
I'm going to say 8913(1), interference. Receiving an email from the head of the personnel department telling me that there is nothing I can do about it was interference on my rights as an
Okay,
employee.
I understand you're saying that there's interference, but my question is interference of what right guaranteed under this chapter?
Well, I'm not a lawyer, so I don't really know. I just know that it was not correct for the Department of Education to tell me there was nothing I could do about my loss of 6 years of accredited experience.
Okay, so you're not sure of
Correct.
what right?
I am not sure.
Um. Sorry, okay. Now, your third claim is that DOE violated section 89-13A7. You can look to that. So it says that it's a prohibited practice or if DOE were to willfully refuse or fail to comply with any provision of chapter 89. Do you see that?
Correct.
Okay. Are you able to articulate to me which provision of chapter 89 that you are alleging DOE refused or failed to comply with?
Once again, I'm not an attorney, and I do not know exactly where the prohibited practice took place. I do know that wages were changed, and I do know that wages are a fundamental element that need to be negotiated, and they were not negotiated.
Okay, sorry, can I go back to 89-13A1, right?
Sure.
Are you deferring to Mr. Reid's explanation of the basis of this claim or not?
Yes,
You are deferring. Okay. In whole,
I'm not an attorney. I don't know. I'm just doing the very best I can as a teacher.
I understand.
All right.
And I would like to explain that I am asking these questions just to get clarity on what the claims are. So
Okay.
if you are deferring to what Mr. Reid said earlier, is it my understanding that that's what you're doing?
Yes. Or
Okay. As to the 8913A1, is
yes,
that right?
correct.
And same question for 8913A7. You just specified that you're not sure which provision of this chapter DOE refused or failed to comply with.
Correct.
Are you deferring to,
Correct. I
What?
will defer to what Mr. Reid provided as his response.
okay. I don't have any further questions.
Thank you, Mr. Takei. Mr. Alapa?
Yeah, just real quick. Ms. Campbell, I'm gonna ask you the same questions I asked Mr. Reid at the end, which pertains to you. Are you a current member of the HSTA?
I am no longer a member of HSTA.
When did your membership end?
I ended my membership on January 1st. I believe it was January 1st, 2023.
And
I would have to check that.
around that time?
Correct.
And the choice to terminate your membership was yours.
Yes, it was.
But during the relevant periods of your claim, HSTA was your exclusive representative.
I thought so.
Well, were they your exclusive representative?
Yes,
And have you ever run for office with the HSTA?
never,
Have you ever been prevented by anyone from running for office?
never,
Did you have you ever been prevented from attending any HSTA meetings?
never,
Have you ever been prevented from voicing your opinion to the HSTA?
Could you repeat that, please?
Have you ever been prevented from voicing your opinion to the HSTA?
So could you give me a little bit of, do you mean person to person, or do you mean myself to all of HSTA? Have I been prevented
Yeah, and it can be
expressing
anyone.
my opinion?
Yeah, expressing your opinions, how you felt about repricing.
That's difficult for me to answer because I did write multiple emails to HSTA in hopes of finding additional people who could possibly be part of our concerns about the loss of 6 years. However, we did not, I don't know. I don't know. I didn't have the forum. I didn't have the support of HSTA. So therefore HSTA did not prevent me. However, they did not help me.
Okay, and that's what I'm just asking about.
Correct.
Anyone prevent you from voicing it? Not so much did they do what you asked them to do.
Right. No,
So no one prevented you.
No.
Yeah.
No.
And nobody prevented you from participating in the discussions or with HSTA.
correct.
Okay, that's all I have. Thank you.
Thank you.
Thank you, Mr. Alapa. Ms. Campbell, again, while it may seem a little cumbersome, this is your opportunity if you want to respond in that way to the questions of Mr. Takei and Mr. Alapa.
Okay, so I just wanted to go back clarify, to help clarify a couple of things that may be in a little bit uncertain on my part, or maybe still it's very difficult for people to understand the salary schedule. So I'm going to try to, and this is in relation to repricing, because this is, and the compression. So the salary schedule of a teacher, if you can imagine, is like a checkerboard. Each of those squares on a checkerboard are a class, okay? So you have a checkerboard, and each of those squares represents a class with a salary within that class. Teachers move from the left side to the right side on the bottom, depending on how much education they have or how much professional development they have. So you can move across. You have a bachelor's degree, you're at one place. You have a master's degree or a PhD. Movement up the class is done through step. Step movement has only happened through collective bargaining. And people have, or you can move up the step as you gain experience. So it can be through collective bargaining, or as in our case, we had 6 years of previous experience. So we started at a higher level. So what is in question here that I have a lot of difficulty understanding is that Mr. Bacon testified that the DOE has taken the position that they are going to stand behind F2, which clearly states the repricing of classes. There was, in fact, no repricing of classes, because he later testified that no negotiations needed to take place. What happened with repricing is you have your checkerboard, you have the classes, the pricing of the classes, and then you have step movement. Multiple times, Mr. Bacon referred to this as people got squished in between. The steps had to be opened up. In other words, what happened with repricing is there was no repricing of the classes as so stated in F2. There was never any repricing of classes. There was never any documentation. There were never any memos, but there was never any repricing of the classes. The classes were each of those checkerboard squares. What happened in repricing is that people moved on the checkerboard. In other words, they gave some people more time and credit. The step movement has never been, steps have never been moved other than through negotiated step movements, which we in our next bargaining agreement, there's 1 step 1 year, which reflects kind of a 3% raise. Then the next year, it's an actual 3% raise. Then there's a step movement. So my question to the board is, DOE is standing behind F2, but how can they stand behind F2 when there was no repricing of the classes, which is clearly stated in the, sorry, I lost my train of thought. It is clearly stated that they needed, that was at their own, I don't have it in front of me. They had the option, or they had the ability to implement that. So that is my question. If I look back at 89.1, and I know it's intent, but the intent also of F2, the intentions of creating the statutes was to promote harmonious and positive feelings between an employee and the employer. F2 in this case is being used in a very different fashion. If the employer had come in and said, all of the classes, in other words, all my checkerboard squares will all change, that would be a repricing of the classes. which it clearly states in F2. That is not what happened. F2 did not happen. They did not reprice the classes. And it's been said here multiple times as we keep talking about repricing, but the classes never changed. It was the step movement that changed. So F2 cannot possibly be used by the Department of Education because it doesn't fall within the parameters. And if I look at what the intent was to use F2, and I think back of the statutes that were created on 89(1)(b), it was to promote harmonious relationships. In other words, the employer could come to the union and say, we are going to reprice the entire checkerboard. We haven't had negotiations. We haven't been able to come to an agreement. Therefore, as an intention of good faith or effort, everyone across the board receives all those checkerboard squares, all change. And that's what repricing is. And so that's my conundrum here. I don't understand why we're talking about F2 when not only is there no documentation, no memos, there's nothing, but it wasn't even repricing according to that statute. So that's what I have to say.
Thank you, Ms. Campbell. Mr. Takei, if
No questions.
questions, Mr. Alapa.
No questions, thank you.
Board Member Moipono, do you have any questions for Ms. Campbell?
Oh, yeah, just a couple.
Sure.
Okay, you said you had worked for 1 year with DOE.
Correct.
The 2000-2001 school year.
I believe it was, yes.
Just but 1 year, one school year.
That was just one school year. Correct.
Did you receive credit for that when you came back to DOE?
I did. I did.
So in addition to the 6 years that you were given
Correct.
credit?
Correct.
Wow.
I started on step 7.
Okay. Okay. So I just want to make sure that I know it's you adopted, sort of incorporated what Mr. Reid said previously in his testimony. Is that correct?
Correct.
Okay. So everything that he said regarding 89(9) F2, that is also adopted.
What I have said in response to 89(9) F2 is my response. I am not going to accept the answer I'm adding on to the answer with my response to 89(9) F2.
And your response was that last bit of
Correct.
Actually, there was no repricing. Is that your response to?
My response is F2, the wording, compression was not done under F2. There was no repricing of the classes, which is clearly stated in that statute. There was never any repricing of the classes. And I believe if we go back to look at Mr. Bacon's statements, he said we're going under F2. And we're saying, the reprices, because people interchange words every once in a while. And then it's very difficult for people to understand this situation because it is quite complicated. You talk about a salary raise, you talk about compression, you talk about a compression fix. You talk about, wages changing, and things get mixed up. So in essence, if you read the statute, if you read F2, it clearly says the repricing of classes. Well, There was never any repricing of classes. And then later, Mr. Bacon states that, well, there didn't need to be any negotiations because, we didn't reprice the classes, but he's standing behind F2 saying the statute says that the employer had the ability to provide these increases because they through F2, through the repricing of classes. There was no repricing of classes. Our complaint is we had 6 years of credited service. The step movement was the important part. People were moved on the checkerboard. The class did not change, but people were moved inequitably on that board. And people who had previously 6 years of credited service were now told that service didn't count on the equation of moving steps, because Mr. Bacon referred to step movement continually. He said, people were compressed, they didn't make steps. So at this point in time, we're talking repricing, but the reality is that in F2, they talk about the repricing, they talk about repricing of the classes, but there was no repricing of classes. It was inequitable movement on the page, on the schedule.
Okay, but this argument then is something that you're claiming for
Correct.
aim in Article 20, Section C.
Correct.
Your same argument. Okay, thank you.
Thank you.
Board Chair O'Shea?
Yeah, okay, so Ms. Campbell, when you returned to the DOE, you had left in 2001, right? And you came
I
back in-
believe I left in 2001. I believe I left in the, I worked for the DOE. There was an issue because I was not an American citizen. And so I worked for the Department of Education for, I believe it was 1 year and then left. Correct. It was 1 year. They gave me credit. Let's just say they gave me credit for 12 months of employment.
Okay, so I think your testimony is you worked from 2000 to 2001.
I believe that
1
was
year
it.
credit.
Correct.
Then you left and I guess you went to a different school.
I did.
Maybe, was that the Sacred Hearts Academy?
Correct.
Okay. So you left from 2001 to 2010.
Correct.
And then you went back to the DOE and they gave you some credit for your time at
Correct.
the Sacred Hearts. They gave you the maximum 6 years.
6 years plus the one I had
Okay.
before.
Okay.
Correct.
So if they had not given you that 6 years and plus 1 year, do you recall what step you would have started at?
I was not familiar really at that time with the, I believe I would have simply started at
Okay.
the bottom.
Okay.
First step one.
Yeah, okay, but I think the testimony was that you were on, before repricing.
Right.
You were at step 11.
Correct. I went up 4 steps in 12 years. I was part of the compression.
Can you explain that? When you said 4 steps in 12 years.
So I entered the Department of Education in 2010.
Yep.
I worked there from 2010 until compression, which was 2022.
Yep.
Which was 12 additional years, right?
Right.
And I moved from step 7, after my initial hire. And I moved 4 steps to step 11.
Okay. So when you first got back in 2010, you started at step 7.
Correct.
And then they calculated in your 1 year of prior experience, gave you another 6 years,
Correct.
and that brought you to the step 11.
Well, I started, I had my 1 year, my 6 years, so I was at step 7,
Yes.
okay? And then I worked for 12 years,
Yep.
and during that 12 years, I was able to work through to step 11.
Okay, does that mean that every year from that period of time, you're going up a step, or you're,
I was going up a step in tandem, alongside my peers. When there were step increases across the board, as they always were negotiated step increases, I went up alongside my same experienced peers.
okay, so okay, I'm just trying to run through the calendar years from 2010 when you came back, after 1 year.
Mhm.
You know, and then you restarted again, DOE, and they gave you credit for that 1 year from 2000 2001.
Correct,
And then they gave you 6 years for the time you spent at the Sacred Hearts Academy.
correct.
And then, so they at that point in time, they set you at a step. And that step, was that step 7 or was that step 11?
No, that was step 7.
That was step 7.
7.
Okay.
Yeah.
So in 2010, I can say it's 2010, you're at step 7.
Correct.
Okay, then from 2010 on, in 2010, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, you finally arrived at a step 11.
Up until 22. So I
Okay.
believe that's 12 years later.
Okay. And that would be at step 11.
Correct.
Okay. Then in 2022, you have this thing called repricing.
Correct.
And what was your expectation as far as any step movement for yourself?
My expectation, because when the publicity, I'll say, or when the memos came out giving information as to what was going to happen, the promotion by both, well, I would say actually was more HSTA, because that's who I was getting my information from, indicated that teachers would be getting, because for so many years, teachers had suffered economic hardship, salaries had been compressed, and it would have, it was time that people were being recognized for their experience, because one of the key items here is our lack of experienced teachers in the workforce. And I think that, and I cannot speak for HSTA, so I won't speak for them, but as a teacher who has been in the department for 12 years, our problem is not having experienced teachers in the classroom. So that was part of the compression fix and compensating teachers for their experience. So my expectation was, I had 7 years. I started on step 7. In 12 years, I had gone up to step 11. And when the calculations, as Mr. Bacon had alluded to yesterday and talked about, my calculation is that I should have moved up to step, I believe it's step 14, but I'd have to look. I've talked about steps.
Are you referencing it?
I am referencing.
What exhibit are you looking at?
Mr. Reid, can you tell me do you know which one would be the salary schedule?
For which
For
year?
compression,
It
compression.
would be the October 6, 2022
See
board
you-
memo.
See
I think
you
it's
17 salary schedule.
it's one of the board. I think it's one of the union or employer exhibits towards the bottom of the list. Actually,
Is that the E0008 that,
The memo? So we could look at the
is that
memo.
October 6, 2022?
or RE1.
Yes,
Okay.
what is it?
Right, RE1, third section, first one,
I'm sorry, first section?
third.
Third.
Ms. Cameron, when you get to your document, let me know and let the parties know by referring to the upper right-hand corner.
Oh, wait, I'm in the wrong place.
It should be an E some number.
Six.
It's sorry, I'm not there yet. I still haven't found it. Sorry, Mr. Reid. I'm in the third section. I'm sorry, what is the number that you have?
Are you talking about the
Yes.
October sixth?
I am talking about the October.
Is that would be E0008.
Thank you. E0008. Okay. And sorry. Okay. E0021.
E0021.
So if you,
Okay, I'm looking at 0021 E, okay,
is everybody there?
Yes,
Okay.
okay,
So I was at 12 years or more, but less than 14 prior to compression.
okay, I see that.
Okay. Once compression happened, okay, I should have been at 12 years plus my 6 years, which in fact would have moved me to step 14.
Okay, I'm looking at
Eight.
E0021, it says section 2,
2-1.
detailed implementation, right?
Correct.
And I see where you describe if it's 12 years or more, but less than, or no, yeah, 12 years or more, but less than 14 years,
Correct.
salary adjustment step 11.
Correct.
Okay, so you're saying that if they counted your 6 years,
Correct.
you would have been at a higher step,
Correct.
at step
14.
14.
Correct.
And then if I look to the left of salary adjustment step 14, it says 18 years or more,
Correct.
but less than 20.
Correct.
And you believe that that's the correct way of applying this well, the schedule, I guess.
Well, the teacher's schedule here, the compression, this is the salary adjustments crediting teachers for their service.
Okay, okay. Okay, good. That kind of, that helps me knowing what you started with, what you believe. And is there a corresponding salary increase to that change from step 11 to step 14?
There is, if you, and I don't know, I don't know if it's found within the, it is not found within this, this memo. But in fact, as I mentioned to you before, the checkerboard, as you go up, each of the classes have a different pay range. So every step you go up, you increase your salary.
Okay, okay. And that's what you believe should have occurred here.
Correct. Correct. Well, I believe that I should have been credited 6 years, which I was initially promised on my initial hire.
So if that had occurred,
Correct.
would you be here today?
Absolutely not. But it had to have occurred for everyone who was credited time.
But just for you, because I can't speak for anyone else.
Okay.
I don't think you can speak for anyone
They'd
else.
be happy.
No, but just for you, Ms.
Correct.
Campbell.
You are-
just for you.
You are totally correct. I would not.
Okay, thank you. And then I want to go back to the questions that Mr. Takei was reviewing with you. And it seemingly he was trying to basically track the similar line of questions that he posed to Mr. Reid.
Correct.
And I know that you're not legally trained, you're not an attorney. So I just want to make sure that when I look at your amended complaint, remember you filed an amended complaint?
Correct.
Are those the charges and the citations to the various HRS sections, also the various sections of the collective bargaining agreement? Are they still the basis for your complaint today?
Yes, they are still the basis of my complaint. My third amended complaint encompasses my complaint today.
Okay, thank you.
Thank you.
Thank you, Chair.
Ms. Campbell, for what, in your opinion, or not what, who, in your opinion, consists or makes up the class for bargaining unit 5?
Who makes up the class for bargaining unit 5? Do you mean what members are within bargaining?
Is it teachers? Is it teachers and librarians? Who makes up the class?
To be perfectly honest, I know I'm within the class, but I'll be perfectly honest, I don't know everybody else who's within the class.
So let's say teachers for sure.
Absolutely.
And when you received the prior step movements, I think you mentioned 4 steps in 12
Correct.
years.
Correct.
When those step movements were they received by, to your knowledge, the best of your knowledge, all the teachers on that checkerboard that you described?
Correct. It was across the board. People had these were negotiated step movements.
And to the best of your knowledge, was any group or class of people carved out from those step movements?
Not that I knew of.
And then I don't know if you still have it in front of you, or if you have it in front of you, but it's 89-3,
I have, yeah.
chapter 89.
Oh, I have 89-13. Does somebody have 89-3?
You don't have
But you can, I don't have
89-3?
it, but I'm familiar with it. If you'd like to.
And I just want to, if you're familiar with it, I want to direct your attention to a provision of it that really hasn't been discussed. And it's towards the end of the first sentence. And there's the disjunctive that leads into it of or. It says other mutual aid or protection free from interference, restraint, or coercion. Is it your position also under 89-3 that applies to you?
I believe it is my position.
Okay, and in what fashion or circumstance does that apply to you?
I believe as an employee, firstly, well, I know we have the union. My first response when I was unhappy with the situation, I contacted multiple individuals at the Department of Education through, HR, the personnel department, offices of talent management, and the emails I received were obvious that the individuals involved had been given directives, because they said they were given directives by their superiors, to say that there was no appeals process to compression, and that there was basically nothing that I could do about it. It was just, there was no appeals process. My pay, when I asked the talent management, they stated to me when I received my paycheck on the 22nd or the 20th of November, I inquired and I said, why do I not have a pay increase? And they said, because compression does not include your prior years of service, and that everyone was referred to the memo, which I referred to yesterday in my demonstration of 6 + 10, 10 + 6, that memo would explain to me why they had taken away my years of experience. Of course, when I read it, it was no clearer as to why my 6 years of experience had been taken away. When I asked for clarification through both the Department of Education and HSTA, The response that I got was that this was done through F2. And therefore, the employer had the right to give the raises as they so choose.
And when you were informed of that, did you question the Department of Education?
I did.
Let me finish. Did you question the Department of Education as to why certain people were not part of this step movement when in the past everyone had been included?
I'm trying to think of my emails. I did not say why one particular would not have been included. However, I questioned why I upped the pay, up step movements in synchronized motion with my colleagues. And suddenly they jumped 2, 3, depending steps higher than myself, and why I remained behind. And they said, because your time is no longer being considered, my previous, and
And I don't mean to interrupt you, but when you say they, is that the Department of Education?
correct. And I need to include HSTA, because these emails, which I had previously submitted to the board in March of 2023 at my pre-trial, I had referenced many of these emails and I had submitted them to the board. So the board is in possession of those emails, which I sent to the president of HSTA, asking for an explanation as to where my 6 years of service had gone. And then the same thing with the Department of Education. I had felt that I had reached a roadblock with the Department of Education because they had said, there's no appeals process. So that door was closed and I should look at the October 6th memo. When I didn't get any further with the Department of Education, I then went to HSTA. And I requested an explanation as to what had happened to my 6 years of credited service.
Okay. Thank you, Ms. Campbell. Mr. Takei, you have any questions based upon the board members' questions?
No, I don't.
Okay, thank
Thank
you.
you.
Mr. Alapa, any questions based upon the board's questions?
Yeah, if I could. Ms. Campbell, I'm gonna I'll follow up on questions from Chair Oshiro regarding your steps. And so, and it's really for clarification purposes. I'm trying to get the numbers straight in my head. So when you returned to the DOE 2011, yeah?
I returned to the Department of Education in October of 2010.
2010, okay.
Correct.
So when you returned, and that was after your initial year or so?
1 year.
Okay, and then you returned in 2010.
Correct.
And so when you returned, you were placed at step 7.
Correct.
If you weren't given the non-BU5 service credit at that point, you would have been placed at a step 5, yes?
I don't know. I don't have the paperwork and I don't know at that time, we're talking 12 years ago. So I'm not sure because things had changed slightly over the years of where people start. So I'm not sure.
So when you left the department, I think in 02?
01.
01. So when you left the department in 01, you were at step 2. Do you remember that?
I do not remember. I'm sorry.
Yeah, and so while you were gone, they kind of reshuffled everything. And the initial step became step 5. Have you heard that before?
I know that people start at different steps, so I'm not sure.
Or for a licensed teacher, it's step 5.
It's so a beginning teacher, step 5.
Yeah, so you testified that you would have been placed at the initial step, which would have been at step 5. You agree with that? Assuming that's the initial step?
Assuming it's the initial step,
Okay.
I'm assuming that's where I would.
And I'll represent to you and we'll get testimony that the initial step when you came back was step 5.
Okay, no problem.
And so
with that representation, if you weren't given the BU5, non-BU5 service credit at the time you returned, you would have started at the initial step, which I represented to you as step 5. You agree with that?
I agree with you.
Okay, so from the point that you returned to the DOE
Mhm.
and up to the implementation of the compression fix,
Correct,
you had moved up 4 steps, correct?
correct.
So at the time of the compression fix, you had moved from step 7 to step 11, yes?
No, not at the time of the compression fix. I didn't move at that time. I moved from 2010 through 2012. I moved from step 7 to step 11.
You went from
7 to 11 within the 12-year period.
okay. So at the time prior to the implementation of the compression fix, you're at step 11.
Correct,
Okay, so from the start, you're at step 7, and prior to the implementation of compression fix, you're at step 11.
correct.
If you started at without the non-service BU5 time credit, step 5, prior to the implementation of the compression fix, you would have been at step 9, correct? If you didn't get that credit.
I would assume your calculations, I'm not exactly sure where this is going and what it has in relevance to what we're living.
I don't need you to guess.
But
Do you know that you would have moved the same 4 steps?
I guess I would have moved 4 steps. If 7 plus 4 is 11, then I'm assuming that 5 plus 9 is 11.
Okay, 5 plus 4
5
is
plus
9.
yeah, sorry.
Yeah. And so when the compression fix was implemented, you did not move back from step 11 to step 9, is that correct?
No, I didn't move back.
Okay, that's all I have. Thank you.
Ms. Campbell, you have anything else to add based upon Mr. Alapa's questions?
I can simply say that wages were changed. That was a core element of the CBA and should have been fixed by
Pamela,
89.
I'm gonna object.
I just need you to respond. to what
Okay, so
Mr.
I'm sorry.
Alapa-
No, I'm sorry. No other questions. Nothing to say.
To any board member might want to any questions based on Mr. Alapa's question?
No, I don't have. Oh, excuse me, I do have one question. So this goes back a couple, because you said you're no longer an HSTA member, but
Correct.
are you still in BU5?
Yes.
Okay, thank you.
Board Chair O'Shea?
No further questions. Thank you.
I don't have any further questions, so Ms. Campbell,
Thank you.
excuse for now. Thank you. Mr. Takei, you expect to call Ms. Best?
Yes, thank you.
Do you want to take a short recess right now before you begin with her?
Yes.
We can go straight through to 4.
Sorry.
I defer to the boards.
Okay, let's take a short recess, 10 minutes in recess.
Let's vote.
Yeah, I know.
We can come back tomorrow.
Sorry for going over, but we need to deal with this.
We are saying that. Thank you. Thank you. Now we're recording.
We're now recording, Mr. Arata. Okay, we're back on the record. Mr. Reid?
Can I respond to his motion to dismiss the claims?
Well, there's a preliminary issue that needs to be dealt with
Okay.
before you get to Mr. Alapa's motion. Is regarding repricing. And I mean, I think I summarized it to say, is it the claimant's position? There was repricing or not?
So our position is that there was a repricing, it just was full of errors. And what the intention of what Ms. Campbell and Ms. Beth said was, when they said there wasn't a repricing, they meant there wasn't a correct repricing. They meant that the repricing moved steps instead of changing the price for the thing. So a more accurate description would be the reprice. There was no correct reprice. There was an action that we're contesting, and the action was called repricing. Their position is, because they both adopted my testimony, was that the homework wasn't done, the procedures and the independent review wasn't done, and it's possible that a correct repricing would involve changing the numbers as well. So they're saying that a repricing happened. To put it in teacher terms, the homework was turned in, the instructions were not followed, the steps beforehand. Therefore, and all the answers are wrong for a different reason. So the homework was done, the action was done. They called it repricing. We are contesting that the repricing was illegal and in error for for 3 primary reasons: no procedures, no existence of a periodic review, and we feel that the repricing should have resulted in a changing of the numbers in the cells and not step motion.
Okay, I understand the underlying arguments. The fundamental question is it the claimant's position that this was a repricing action or not?
Yes, it was a repricing action. And if I can have one more thing. One of the points of confusion was when Miss Best said they added a class, she was referring to the PD reclassification, not the classes to be repriced. It is a similar root word in that, but she meant class 8, which came in with the negotiations after repricing. When she said they added a class, and I think that was a big point of confusion. Adding a class was not associated with repricing of the classes. Separate.
Mr. Alapa, you want to respond?
What I think I'm hearing is that all 3 complainants maintain their position that the union failed to negotiate when they allowed the employer to utilize 89F2 instead of 89F1. Is that their position?
Yes.
Okay. I withdraw. If they withdraw any inconsistent testimony to that, then I understand now.
Okay, thank you.
You know, this might be appropriate at this time, and if it's not, I can continue the discussion tomorrow. Issue number 7 against HSTA, because all 3 complainants have now testified, is that a group of teachers from the mainland portion of the United States were discriminated against. And we heard testimony today that they all agreed that repricing didn't occur because of their race, ethnicity, where they were from. That was all agreed to by the complainants. And in fact, we have one complainant whose non-BU service time was from Honolulu, Sacred Hearts. So I think based on the evidence provided from the 3 complainants, number 7 should be dismissed. There's nothing to substantiate that claim. And that's a part of our claim, and it would help us to speed things along for the union's case in chief.
And I understand, Mr. Alapa, and on that one, because of the time of day, we'll take it under advisement and let you know at the beginning of the proceeding tomorrow morning.
Thank you.
You understand, Mr. Reid, what
Yes.
Mr. Lapa just said? Okay, thank you. Anyone have anything further for Ms. Best?
Nothing from you.
Mr. Takei?
Nothing for Ms. Best.
Board Member Moipono, anything further? We can't hear you, but I understand you don't have anything further.
I have no question. Thank you.
She needs to be close to it.
Board Chair O'Shea,
Nothing further, thank you.
and I have nothing further.
Thank you.
Ms. Best, you're excused as a witness. Thank you. Mr. Takei, you gonna have any further witnesses for your case?
Yes, thank you. Based on the testimony that's happened since Mr. Bacon left the stand, I hope to recall him as a witness to testify a little further about the procedure required in F2 based on some new information that Mr. Bacon seemed to have acquired between yesterday and to today.
Well, even before well, I'll let Mr. Alapa, what is your position?
I've already taken the position that I do take issue with testimony that was given by Mr. Bacon. I intend to request that I be given the opportunity to call him as a rebuttal witness. If he's allowed to testify tomorrow morning as part of the employer's case, I'll withdraw my request.
Mr. Reid?
I object to any new evidence that wasn't timely submitted at the pretrial conference. They had advance notice of these issues. They had advance notice of exactly what the charges were in regards to this topic, and they did not submit their exhibits in time.
Well, I don't think we're talking about exhibits, Mr. Reid. I think we're talking about just recalling, Mr. Bacon as a witness. But I understand. I understand. Mr. Takei, I have to be honest with you. I have a real problem with this. I don't have a problem with Mr. Alapa's request for a rebuttal witness. But I have a real problem with your request because as far as I can recollect, I don't think everyone has had full and complete ability and availability to question Mr. Bacon. And the fact that you tell me that he's acquired new information overnight, just I'm trying to find a way to even try to navigate around the prejudice of that. And honestly, right now, as I'm sitting here, there is no path in my mind around that. So as far as your case is concerned, I'm going to respectfully deny your request to recall Mr. Bacon in your case in chief.
May I add any more statement? No.
You can if you want to. I'll let you make your record.
Well, Mr. Bacon testified that to the best of his knowledge, he wasn't aware of any written procedure. And but it was to the best of his knowledge, and we didn't anticipate the amount of weight that was going to be put towards whether the procedure, I think established procedure, I believe, had to be written. And and that to be honest, came as a surprise to me. Mr. Bacon, he testified what he testified, that to the best of his knowledge, he wasn't aware of any. He went back, he checked, and he found that, there's new information to, I guess, supplement his understanding. And the purpose for my request to recall him is to allow Mr. Bacon to, give a more complete understanding of the repricing review procedure.
Well, let me ask you this, Mr. Piquet. Are you saying that you and your client were not aware that one of the claims in this case involved 89.9F2?
We were aware, yes.
Okay, as you were aware from the time of the complaint through the amended complaints that that was an issue, correct?
Yes.
Okay, and so Mr. Bacon came in here and not only testified in Mr. Reid's case, but testified in your case in chief, right?
Yes.
And so what you're telling me is you want the board to cure the fact that Mr. Bacon didn't do his own research into an issue that's been front and center in this case from day one. I mean, that's really what you're asking us to do.
Well,
Am I wrong?
well, I wouldn't necessarily put it in those terms. I guess we believed we had the explanation of how DOE, reviewed repricing, this type of stuff. It wasn't until yesterday and the cross questioning that so much emphasis was going to be put towards whether it was in writing or not, and there was no way to anticipate that. At least that's my personal belief, and so Mr. Bacon testified as well as he could with the knowledge that he had, and and he just acquired more information. I have nothing further to say. It wasn't, my request isn't for you to save me or anything. No, my request is just to for the board and for this case to have all the information that's relevant. So the board has all the information it needs to consider the proper outcome in this case.
And I understand, Mr. Takei, and that means a full and fair, complete opportunity to question a witness, which was done not only once, but twice with Mr. Bacon. So Mr. Reid, you can respond.
I was just gonna say that Mr. Bacon testified in a near identical case in April or March, and the issues were the same. He has had, this is the state of Hawaii, not a small business that doesn't have the resources to be prepared and have the resources to search for documents, and the standard for a fully represented state government to present their case correctly has to be the standard. I have presented my case with what little I have.
And Mr. Takei, and another concern of mine is if, it's a huge if, I allow you to do this, then what's to stop Mr. Reid or Ms. Campbell or Ms. Best from going home tonight, doing a bunch of research, and coming back in tomorrow morning and saying, hey, we want to introduce this, we want to introduce it, we want to retestify because now we got more information. It's a slippery slope. And so what weighs heavily against me allowing you to do this is the fact, again, that Mr. Bacon not only testified once, he's testified twice already. And in your case in chief. Now, the fact that Mr. Bacon maybe didn't check in the right places, he had his full opportunity to explain. And frankly, I'm very troubled by the fact that he's already testified that there were no procedures applied to this repricing. And now all of a sudden, overnight, he's gonna produce something that claims to be the procedures. That's very troubling to me. I'm not speaking for the rest of the board, I'm speaking for myself. That's very troubling. So I am gonna deny your request. Mr. Alapa's request will, remain open, and we'll cross that bridge when we get to it. But as far as your request is concerned, I believe it's too prejudicial at this point, and would be unfair at this point in the case, under the circumstances of the case. So I'm going to deny your request.
Thank you.
Yes, Mr. Alapa.
Can I ask a housekeeping item for
Sure.
the union's case? And I've been allowed to participate in the employer's case. Can I just confirm that I'll be able to use testimony from the employer's case, just so I don't have to ask duplicative questions of the witnesses or recall anyone?
And my general answer would be yes, but I think, we can take that up, situation by situation, but I, in general, yes.
Thank you.
Anything further from any other parties? I thank you for your patience. I know we went overtime today, but we'll start again tomorrow at 9 a.m. Recognizing the fact that Ms. Eshelman needs to get on the witness stand and off the witness stand tomorrow, and we're very sensitive to that.
And I think we can begin with her first, right?
Yes, we're first in my.
Okay, so thank you.
Fantastic. So we will see all of you tomorrow morning at 9 a.m.
Thank
Can we
you.
stand in adjournment?
Okay, the binders.
Oh, yeah.
Thank you.